The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Good morning. We have 3 arguments on our submission calendar this morning. First is 19-233, Concho Resources versus Ellison from Erie County and the 13th Court of Appeals District.
May it please the court, Mr. Young and Mr. Keltner will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Young will open with the first 12 minutes and will present the rebuttal.
May it please the court. The Court of Appeals opinion in this case turns the law of written boundary agreements on its head. The court's imposition of requirements for uncertainty at the time of the original conveyance, that uncertainty be objective rather than subjective, and that the boundary agreement must use special words to qualify as a conveyance, will work together to preclude the use of boundary agreements in most, if not all, cases. Now, a boundary agreement can be one of 3 things. First, it can be a contract in which each party agrees to recognize a particular boundary. Second, regardless of pre-existing uncertainty, it can create equitable defenses to a claim of a different boundary, such as ratification, waiver, or estoppel. And third, regardless of uncertainty, it can operate as a conveyance, quit claiming to each party the property on that party's side of the boundary. In each case, the purpose is to establish a consensual boundary and to free the parties from the threat of lengthy and expensive litigation, such as this litigation, which is in its 8th year. Now, assuming for the moment that uncertainty is required, the Court of Appeals erred in looking for uncertainty at the time of the original conveyance in 1927, rather than at the time of the boundary agreement in 2008. Boundaries that were once certain can become uncertain as memories fade or are lost to death, as surveyors' monuments fall down, as rivers change courses, as fences fall, and as courthouses burn.
But Mr. Young, excuse me, but didn't in this particular case, the boundary set out was the road and it did not change? Isn't that correct?
There is evidence that the road did not change. The boundary was set out as the road, but the tract to the north and west of the road was described as 147 acres, more or less, in some instruments as 147 acres with no more or less. And that is not even close to the acreage north and west of the road, according to its location under some of the evidence.
Does that matter considering that the entire tract, I believe, was 640 acres?
Well, the section was 640 acres, as most sections are. In 1927, the executor conveyed the land north and west of the public road, comprising 147 acres more or less, and 3 years later in 1930, conveyed 493 acres. So even as early as 1930, either he had conveyed the same land twice, or there was uncertainty as to whether the tract conveyed in 1927 was 147 acres or some different amount.
Were they going or acting generally under the premise that the road was the dividing line?
Vis-a-vis the surface estate, the record does not show. Vis-a-vis the mineral estate, there were no wells drilled in the disputed territory or the ultimately disputed territory until 2008. Right. So it was a moot point until then. And prior to that time is when Sampson took steps to get the boundary stipulation and the letter agreement.
Mr. Young, I understand your argument based on Gulf Oil versus Marathon, which the Court of Appeals relied on, that the existence of uncertainty is really a holdover from the statute of frauds that's not necessary. But if it were necessary, it says the existence of uncertainty, doubt, or dispute is essential. So do we have to have uncertainty under Gulf Oil, or is dispute enough?
I have been using uncertainty as a catchphrase, but it is uncertainty, doubt, or dispute. In fact, the parties to the boundary agreement did not say they had a dispute. It said that they were uncertainty. Questions had arisen as to the boundary.
But it seems like they did have a dispute. Otherwise, why would they enter into a boundary agreement?
Well, because Sampson wanted to drill a well, and it was not going to drill a well in the face of uncertainty whether it had the mineral lease to the property where the well would be drilled. So all of this was triggered by Sampson's wanting to drill a well, and presumably they investigated the title, realized that there were some problems, reached out to the mineral lessors and said, can we resolve this before we drill a well? And the answer turned out to be yes. And so they proceeded accordingly. There was not, to my knowledge, any time where one party said, no, I own this, and the other party said, no, you own that. Boundary agreements stand in stark contrast to correction deeds, whose purpose is to resolve errors that existed at the time of the original conveyance. Nothing in the boundary stipulation in this case said there was an error in the 1927 deed that needs correcting, nor likely could they have done so in 2008. And consequently, the Court of Appeals should not have applied correction deed principles to the boundary agreement. The court also erred in holding that the uncertainty must be objective. The whole purpose of boundary agreements is to resolve subjective uncertainty, to provide the parties with an alternative to resort to the courts to resolve their subjective disagreements or uncertainty. Had Sampson not been able to reach a boundary agreement, it would have had to file a suit to declare the state of title, and that would have involved the expense and delay that it sought to avoid and the other party sought to avoid by the boundary agreement. If in fact objective uncertainty is required, the purpose of boundary agreements would be thwarted because they would be at the risk that someday some court would say party A was objectively right and party B was objectively wrong, and accordingly, the boundary is not where it was stipulated to. That is, in fact,
what is your response to the argument that this is all having retroactive effect?
It is not having retroactive. It would be having retroactive effect if we were contending that Ellison, without more, were bound by the boundary stipulation. The boundary stipulation purported to be retroactive, and it may have been retroactive between the parties, but we did not rely on the retroactivity as a ground for binding Ms. Ellison. She was bound because of the ratification that her husband gave in the letter agreement. So even if the boundary stipulation were ineffective retroactively, it served as the basis for the document whereby Mr. Ellison ratified prospectively the boundary between the two tracts. Retroactivity is immaterial if you assume that the boundary stipulation is not retroactive, the outcome of the case is the same. That brings us to the alternative status of the boundary stipulation as a conveyance. The Court of Appeals said it was not for three reasons: because it was supposedly void for want of uncertainty, because it did not identify grantors and grantees, and because it did not contain words of conveyance. The respondent does not defend these holdings, and they are indefensible. First of all, uncertainty is not required for a conveyance. I can convey my property to you even if I know full well that it belongs to me and that the boundary is what it is. Furthermore, the boundary stipulation identified the parties and specified that each party would thereafter hold title to the tracts identified on the exhibit to the boundary stipulation, and therefore adequately identified the grantors and grantees. And as the respondent has acknowledged, it contained general words of conveyance. And so even if the Court of Appeals were right that the relevant uncertainty is 1927, and that the relevant uncertainty is objective, and that there was no historical objective uncertainty, it would nevertheless be wrong in refusing to give effect to the boundary stipulation as a conveyance.
Counsel, how do you respond to the amicus brief filed recently by the Land Title Association, which argues that your position is going to create uncertainty and cause confusion for people searching title records?
I respond this way, Your Honor. If we were arguing about actual title in this case in this court, then I would understand the point about interpretation of more or less language. But we are not arguing actual title in this case. The question is there uncertainty raised when a 301 acre alleged tract is described as 147 acres? And there's plenty of authority that it is. In Sims versus Haggard, this court indicated that minor discrepancies are to be ignored, but in the face of a massive discrepancy such as this one, there is a potential claim for equitable reformation. The issue is not what a title abstract would or should show and what a land title examiner needs to do to go out onto the property and measure how many acres are north and west of the public road. The question is uncertainty created when a 147 acre tract is described as 301 acres or vice versa? So with all due respect to the TLTA, they do not need to be worried about this court's decision in this case. I believe that concludes my opening time.
Any other questions? Thank you, Mr. Young. Mr. Keltner, we'll hear from you.
Thank you, Your Honor. This may be the first time that I'm not lying when I say I'll be brief. After all, I've only got 3 minutes to try to convince you that Chapter 91 elements are not met here. First, let me say that Ellison concedes, and it no doubt has to, that the truth of the matter is that if the title issue goes against them, all of their claims go away. Second, under Chapter 91, Sampson was the operator, not Sunoco, and the statutory payor. Sunoco never was, and that's important in this case because Ellison originally claimed it was Sampson who was the operator and sought Chapter 91 damages. We settled and were released, and then Ellison convinced the 13th court that actually it was Sunoco that was the operator. And that is just simply not true. And in fact, that's conclusively disproved. I've provided a bench book for you because we have only a brief period of time that paraphrases a graph in tab 1 of Chapter 91's definition of payor. 2 ways you can get it. One is if you undertake to distribute proceeds. Sampson, not Sunoco, was the only one that did that. And then second one, if you enter into arrangements with the first purchaser, and that would be Sunoco, that the first purchaser pays the person with the right to produce, that would be Sampson, then the operator or the person, the operator becomes again the payor. And there's no doubt that that happened as well. Under tabs 2 and 3, I give you the undisputed evidence that supports this and conclusively proves our point. Let me say this. What Ellison really says is, no, wait a minute, you can become a statutory payor under the Prize Energy versus Hoskins case by undertaking to make a first purchaser purchase. Nothing in the statute says that, number one. Number two is there are two other things wrong with that case. First off, it's not a petition denied case as they say it is. It's a no petition case. And then additionally, all it held, in fact, in that case, there was no purchaser, much less any first purchaser. What the case really holds is that an operator, by tending to operate, would have to undertake the obligation to pay the non-possessory royalty interest, which is not involved in this case. And let's assume that case is correctly decided. Then the truth of the matter is this: Sampson was the operator. Therefore, only Sampson would be liable even under Ellison's theory. So on that basis, we would ask you to reverse the Court of Appeals decision. The court should have granted the summary or affirmed the granting of the summary judgment in favor of Sampson and Sunoco.
Any other questions? Thank you, Mr. Keltner. We'll hear from the respondent.
May it please the court, Mr. Baxter will present argument for respondent.
May it please the court. I'll forego the opening that I was going to give by just responding in fewer minutes to Sunoco than what Mr. Keltner did by saying that's strictly statutorily a Hofeldian rights analysis. The right to produce is the legal right to produce, and a trespasser does not have that right, and that's the only way that Sunoco could get off the hook. In the recent argument, Regency Field Services, I believe it was Justice Boyd who indicated that in discussing underground trespass, that the trespasser did not have the right to produce, and you're trying to form your jurisprudence around how much interference constitutes interference with the right to produce. In addition, I would bring to the court's attention a case that discusses from the standpoint of Railroad Commission regulations, Unit Petroleum versus Davis Pond Well Service, 439, third, page 389, cited in the Endeavor versus Discovery case recently that talks about the language right to produce under Railroad Commission regulations, because you have to be operating under a valid permit, Railroad Commission permit, in order to have the right to produce as well. And that's an essential requirement for being able to get off the hook under the division order statute for Sunoco. I might also mention a case that was just decided on December 9th in the Eastern District of Oklahoma against the two Sunoco defendants, and that is Klein versus Sunoco, and it incorporates an earlier opinion they had, and it was under the Oklahoma division order statute, and they found that the arguments, same arguments that Sunoco makes here, defied logic, and their conduct was reprehensible by not following their division order statute and paying late interest to the legally entitled payees. I would incorporate every one of the arguments in the Eastern District's opinion. They found $80 million of actual damages for failure to pay late interest and $75 million of punitive damages, and said they could have doubled that to $150 million of punitive damages justifiably. Now back to my title argument. This case is disposed and the adverse amici are negated simply by the conclusively established location of the public road boundary in the 1927 deed and application of the Stribling versus DPC Milligan rule of property law, which has been well settled since 1891. All defendants' arguments must start by undermining Stribling, and which said that to do so would reduce tracing titles to a mere guessing game. That alone makes the stipulation void, invalid, legally ineffective, because first, the boundary was already objectively established. Second, estoppel by deed precludes any of the parties to the stipulation or the Concho defendants from arguing subjective uncertainty, and thus the stipulation is a retroactive impermissible correction deed that is void and cannot be ratified, as the Texas Land Title Association amicus brief and our briefing pointed out.
Mr. Baxter, why can't parties agree to a boundary line regardless of uncertainty?
Justice Learman, they totally can agree. And that's the point. They're conflating boundary agreements with agreements to establish an uncertain boundary. Those are two different things entirely. In my briefing, I pointed out that in our form books for real estate documents, Form 26-7 is a 1.5-page document that allows anybody at any time to do a present grant, cross exchange, and say, this is where we want our boundary to be going forward. This whole setup was a pretext, as my briefing pointed out, and I'll get to in a minute. Sampson, from the very beginning, 2 years before the 2008 boundary stipulation that the landman for Sampson wrote, had already falsified the boundary from the 1927 boundary. If you look at exhibits 4 and 5 in our oral argument exhibits, on the same day in 2006, they first had the public road boundary in a survey plat, and then they omitted it and called their new imaginary line the boundary line. That's the falsified plat that they filed with the Railroad Commission, and all defendants did for all their wells. All right. At any rate, this case is also disposed expressly by Ricane 1 and 2 that expressly said that their two equitable defenses are inapplicable. It's also disposed by the adversely admitted, conclusively disproved proof element for both of their equitable defenses that also invalidates the boundary stipulation as to Jamie Ellison's state of mind at the time of the letter, which Concho admits, and it's on page 15 of its reply brief, that he erroneously knew and understood the 1927 deed tract was limited to an exact 147 acres, and the true boundary of his leases and the common boundary with the Suggs leases was the Sampson new boundary line. Mr. Young may not be aware, because of what he just said, that in 2006, 1 month before their lease, the lessors of the Sugg lease recited as to their quote 493 acre tract that its boundary was the public road and their land was only located on the south and east side of it. Every one of the 6 title opinions had a requirement that said the 1930 deed, which Mr. Young tried to say conveyed 493 acres, had no boundaries. It was the so-called 493 acre tract. And nowhere in their chain of title other than the 2006 deed do they ever indicate that it had a boundary. There's so much more. And in their title opinions, they also said, and that was addressed to Sampson's Tim Reese, who wrote the stipulation, that there had been an 80-year common understanding between all the parties on both sides of the road that the road was the boundary, and there were fence lines for 80 years on each side of that road.
Mr. Baxter, I'm sorry. What is your answer to the argument that the 2008 letter qualifies as a ratification? What is your response to that?
Well, first of all, even if it did, the boundary agreement is void and you can't ratify it by a letter like that. Secondly,
well, that's part of my question is, let's say, and that's your answer, that it doesn't matter.
That's one. There are about 5 or 6 reasons, but another one is it says it's accepting the description. And if you look at the Westbrook versus Atlantic Richfield case, it says that, and this is a textualist court, it says we're accepting the description for use in that second, more formal recordable document to be used. And that was the only document I was concerned about from a title standpoint. That would have had to be the ratification. If you look on page 9 of their summary judgment motion, where they're quoting one of my emails, I'm inquiring of all of them, do you have a countersigned copy of this letter even? And by the way, there is a conclusive evidence, and they judicially admit on page 9, they never even knew the 2008 countersigned version of that letter existed prior to this lawsuit being filed. But at any rate, it says accept the description. Same thing as in the Westbrook case for use in that second document, which, as we've noted, was a condition before there would be any enforceability anyway. So that's a couple of my answers to that question. I would bring to the court's attention also in connection with agreements to establish an uncertain boundary, an update that just came out on December 21st in volume 72 of page 132 of the ALR, updating an earlier article exactly on this point: sufficiency of evidence to make valid an agreement to establish an uncertain boundary. It agrees with all our briefing on the issues, cites our same cases, Boyd versus Hunt, Harn versus Smith in 1891, and all the others, and says, when a boundary is objectively ascertainable, when it's plainly described in deeds, when it's plainly marked on the ground, there is not sufficient uncertainty to be able to make valid a boundary agreement. And a case I missed and that wasn't cited in the 25 or so cases in Gulf Oil is Lease versus Barnett, which is exactly this case in 1934. The losing party asserted that they could change the boundary in a previous recorded deed with a plainly marked boundary on the ground and a plain description to coincide with the nominal acreage, more or less, that was in the prior deed. And the court said that was an erroneous supposition under the law, and there was not sufficient uncertainty to be able to make an agreement to establish a boundary. They could have done a present grant boundary at any time. There's no
Mr.
time.
Baxter, what do we do? What do we do with the 2008 agreement, the language that says it shall be deemed to contain adequate words of grant and conveyance necessary and proper to transfer and vest the ownership of the mineral estate? Doesn't that seem more than just an agreement about a boundary?
Well, and this also answers as another reason for Justice Lehrman. It's possible to ratify a 2008 boundary stipulation dealing with mineral ownership without changing the boundary of the leasehold, which is exactly the situation that was in Gulf Oil versus Marathon. But to your point, Justice Bland, I'm the one who argued in the trial court that every agreement to establish a boundary is a conveyance. Mr. Young's the one who argued it was only a clarification of the 1927 deed, of an unambiguous description that they were trying to clarify, which is the whole policy problem with title examination when you try to change retroactively unambiguous conveyances, as the title insurance industry said. So I'm the one who's always said it's a conveyance. That's what makes it, and it's retroactive. And you can't pick and choose whether we're going to only apply it retroactively or not. It didn't matter whether it had the effective date of 1987, making it retroactive to the exact date of our leases, which is part of their whole pretext setup. It would have been a conveyance anyway, which subjects it to correction deed law. You can't retroactively materially change, as this court said in my read, and prior unambiguous deed. It completely blows up our whole recording system, constructive notice, our title examination process, all of which are part of the reasons for the policies and stability and certainty of titles that this court does not allow categorically equitable defenses to be used in trespass to dry title case. I find it highly ironic that Mr. Young says what we're arguing about here has nothing to do with title in a trespass to dry title case. Did that sufficiently answer your question, Justice Bland? All right. I have so many reasons. In addition, another requirement for agreements to establish a boundary that was in Gulf Oil, and look at the Galbraith versus Lunford's case cited in that case, the agreement cannot be lacking in good faith. The whole setup here was a pretext. The land grab scheme document, starting with exhibits 4 or 5, where the boundary, nowhere was the boundary anything other than the public road until the survey plat by Sampson 2 years before the boundary stipulation that drew the imaginary line. And then in the second survey plat on the same day, they take out the public road and put in their imaginary line as the boundary of our lease, and then don't notify us about that when they filed it with the Railroad Commission. The 2007 surface deed that Mr. Reese creates, Phantom 154 acre deed, says there was an express reservation of 154 acres in the 1927 deed. And I'm assuming the court knows we're not talking about a difference of 154 acres in a 147 acre tract. We're talking about a 9,000 acre land swap Today, we'd call those Section 1031 tax-free exchanges, and they're upsetting and disrupting that entire area of law and claiming that you couldn't have a 154-acre difference in a 9,000-acre land swap. And they mock me for saying, which is true in the affidavit of one of our county commissioners, you could buy a whole section of land back then for the price of a horse saddle. So a quarter of a horse saddle is the difference in a 9,000-acre land swap, and that's terrible. And we're going to go back 80 years and reevaluate it and determine, oh, we don't know whether one had water. The fence lines were already in place. It would cost more to change the fences than it would to come down to exactly the place. And I had all that detail in my statement of facts about why they would go to the road, to the fence lines that already existed, with the fence posts being older than 1927, even today, right there. At any rate, all that's involved in why the boundary stipulation is not a boundary agreement. It's an attempt on a pretext to retroactively change an unambiguous boundary, which completely violates correction deed law and all the other principles, stribling and everything else that's included and reinforced by the Texas Land Title Association amicus brief.
Is there any, counsel, is there any indication of why Mr. Ellison signed the acceptance? Did you contend he didn't really sign it, or he didn't understand what it meant, or what do you think happened?
Well, they've adversely, I think, Your Honor, we have a judicial admission on page 15 that in the conversations with Tim Reese, he told him that we were only entitled to an exact 147 acres and that the boundary, therefore, was this other boundary. If you look at the 2008 stipulation itself, it falsely claims that the survey that came with it, which was merely a repeat of the false 2006 survey, was an update of an actual survey of the 1927 deed tract in the 1927 deed. And they even put the recording information for the 1927 deed on the survey. Now, Mr. Young's brief left out all that language that's actually on that survey, and we pointed that out at the petition stage, but it's there. And so anybody reading that would say, well, great, here's an updated survey of the original 1927 deed tract, and it has the recording information, and it completely disregarded the public road. It used the new imaginary line, and the Ellisons in their affidavits, these are unsophisticated people, high school graduates. They say, just like their former partner, County Judge Ellison, they didn't examine title when they took over a small well, typical West Texas deal. It produces $3,000 to $10,000 of profit a year. They didn't examine the title. They had not gone back and checked the 1927 deed, and that's what they were faced with. That would be some of the reasons why it's there. But Concho admits that was his state of mind based upon the conversations that Mr. Reese had. And on page 9 of their summary judgment, on page 15 of their reply brief, they quote out of Sampson's Reese's affidavit where he makes that point. They were very proud of all this because this was going to show that there was a contract or an agreement of some kind, but it's totally based on misrepresentations and pretext. Okay. For the reasons I've mentioned and for many more in our briefing, the title is disposed in favor of Ellison. I might at this point mention that Concho, despite the fact they say trying to find a little bit of light for their bad faith trespass finding, they try to say, well, there's no evidence as to when they actually knew about an actual countersigned or alleged countersigned version of the 2008 letter. But on page 9 and 17 in their motion for summary judgment itself, they judicially admit that it was only during the discovery stage of the litigation that they located or discovered the allegedly countersigned letter. And that was the aha moment for them. They also have included as Exhibit C1 the full email of an exchange I had. They quote 2 paragraphs out of that exchange just above their judicial admission on page 9. But the missing paragraph in between those is where I recounted that I'd already talked to Concho, already talked to Three Rivers, asked them if they had a countersigned copy of that letter. Remember, the only thing I was really concerned about was the second document, the more formal recordable document. That would have had to be the ratification to ratify a void document. in present grant language, not retroactive language, so as not to violate all the title law principles involved. At any rate, in that paragraph, I recanted, I talked to both of them. Concho had sent me only an unsigned copy of that letter and said they didn't have one. Three Rivers said they didn't have one, didn't know about the existence of one, sent all their documents to Concho. And then my tab Y of evidence in our appendix of evidence, which you have physically because it couldn't be electronically transmitted, describes all this, fills in all the blanks, and confirms why when they sent a December 2013 letter, that's what the Court of Appeals picked up on to say 6 months after we filed the suit in June 2013, it was only in December 2013 when they discovered this signed letter. And of course, they can't rely on something they don't even know exists. But my tab Y includes as an exhibit the formal letter back from Sampson saying they didn't have any documents. They didn't know about the existence of an unsigned letter either. Your Honors, I have a whole nother page I could talk about why this court really has established a rule since the early 1890s, beginning with Duran versus Railway. And I think the landmark case is Montgomery versus Trueheart, one of my favorites. I cited in Ricane. Smoot versus Woods in Ricane 1 cited Trueheart. And it actually says that you cannot divest a vested title by equitable defenses and trespass strike title. We need that categorical rule to avoid what's happened in this case, where I've had to devote 8,000 hours and I devoted 13,000 hours in the Ricane cases to having to do what really meant to fight off the equitable defenses, when all that really mattered in both those cases was the simple construction of a single document. In Ricane, it was a quitclaim assignment, and here it's the 1927 deed, which Stribling says is unambiguous, and it would really disrupt our entire title examination process and title law principles if Stribling is not honored and followed.
Any other questions? Thank you, Mr. Baxter. Mr. Kellner, I believe you have 5 minutes. Or Mr. Young.
I want to assume that almost everything Mr. Baxter just told you is true and cite to you your case of Reserve Petroleum versus Hodge. There, an original deed was void for want of a property description, but the party subsequently executed mineral leases which contained the property descriptions. And this court held that those acts constituted a ratification of the deed and were valid. If in Reserve Petroleum, then so too here, regardless of the status of the boundary stipulation. When Jamie Ellison signed the letter agreement acknowledging the boundary set forth in that stipulation as the boundary of his leasehold, he created a ratification. Now, Mr. Baxter says this case is anomalously, supposedly not about title and yet is a trespass to tri-title case. It is about ratification and estoppel as precluding particular claims of title. And we've cited at pages 15 to 18 of our reply brief numerous cases from this court holding that equitable defenses are indeed available in a trespass to tri-title case. With respect to retroactivity, I would call to the court's attention the Montgomery case cited on page 15 of our reply brief. And that case holds that a conveyance that cannot validly be applied retroactively is nevertheless valid prospectively. And so regardless of whether the boundary stipulation could make itself retroactive to 1987, it was certainly effective from and after its execution in 2008. Mr. Baxter spent a lot of time discussing details which he says show that title was in Ms. Ellison to the full 301 acres. I could call this court's attention to evidence suggesting otherwise, in particular the 1930 conveyance, but also a 1927 deed stating 147 acres with no more or less language. But all of that would be ultimately beside the point. The whole point of boundary agreements is not to have this kind of argument about title in the Supreme Court of Texas 12 years after the boundary agreement. The purpose of the boundary agreement in 2008 was to settle the title once and for all, as it did between the mineral estate owners. The purpose of the letter agreement was to bring the lessees into the loop and to subject them to the boundary agreed upon in the boundary stipulation. All of that happened in 2008. It should have been respected by the Court of Appeals. This court has many, many decisions holding that boundary agreements should be free of judicial second guessing years later. That is exactly what happened in the Court of Appeals in this case, and exactly why we believe the Court of Appeals should be reversed. So we ask this court to reverse the Court of Appeals, to render judgment on Ellison's claim and on our counterclaim for declaratory judgment, and to remand the case to the Court of Appeals for consideration of our cross appeal. I'd be happy to answer any questions the court might have.
Any other questions? Thank you, Mr. Young. That
Thank you,
concludes the argument in the case. The case is submitted and the court will take a brief recess. Yay.